Hi guys, it's Kathy. I hope you're doing well. We have a tiny problem this morning. Not a big problem, just a tiny problem. I'm going to share my screen, but I can't scroll any lower because I don't want you to see what's coming up. Because something is coming up. So, it, I don't know where we left off. So, I'll tell you why I don't know. I remember we were partway through a video that was an hour long, and we had like 20 minutes left to go of it. So it's probably this one. This one is probably it. It it could be this one. It normally tells me where I left off, but you see these two have little red lines. I didn't pre-watch any of these, so I don't know how they got there. But it messed me up because now I don't know where exactly we left off. So, do we remember her in this dress? It could be this one right here. So what I'm going to do is I'm going to press play right here. Where's Kelly? She'll have the timestamp. I'm going to press play right here. And I'm going to go back like just a minute. And we're going to see if we would be watching 22 4. Bren. I'm Oh, I wish I could put Facebook messages on. Bren just said we are watching 22/4/19. Now, to Americans, he really means 4/22/19. So that is so helpful. Oh, I'm gonna try this one right here. I'm gonna try this one and see if it says 22/4/19. It does say 22/4/19. We have about 20 minutes left. Remember yesterday I said, oh, there's like 20 minutes left and courtroom cat is starting. This might be it. I'm going to back it up just a minute and let's see.
You're disqualified, so
I understand what happened, but he still needs to have someone cover for him. So I have to have this hearing, and I will notify him as to what my decision is. But
No.
I have to conduct this hearing because I can't let it sit any longer. So especially not until however far out it is that he was requesting. I mean,
it was 1 week.
No.
No, we didn't see this yet. Are we agreed with that? We did not see this yet. So it had to have been this one right here. Which dress? What does that mean? I don't understand. Which dress? This is the old. Is that not the old judge? So we have to be down here more. But I don't remember seeing this. I am so confused. Oh, I don't want to scroll down. I don't want you to see. No. We definitely are in this judge.
Okay, we are on the record in case D. I just want her to understand that I've been very patient. A lot of people would not have been that patient. A lot of judges would not have been that patient.
And I'm also
Okay, this is May. So this cannot be it.
Cover for him. So I have to have this hearing.
We did not see that.
We're on the record in case D 572-482.
This is where
We've
we're at.
addressed all of that. So now
Yep.
he needs to have his custodial time.
This is
because
where
it's
we're at.
ordered. It's
Right,
been
but
ordered.
okay, so I didn't know that you aren't able to
I'm going to fast forward a little bit.
change the because I didn't know.
In the meantime, you have orders to
Good enough.
follow. You still have orders to follow, and there's nothing that stays the orders. Okay, the orders are in effect; they still need followed. I can send that motion to her to hear.
Now that he has the baby, now that he had the baby, he just didn't care.
To me, when it comes down to the money issues, how he Okay, so the orders are in effect.
Oh, I'm muted.
If you want me to send that motion to set aside back down for the limited purpose of Judge Marquis hearing the motion to set aside or to
This
reconsider,
is where we're going
I will
from.
do that. And she'll issue her order. And if in fact she sets aside the order, I will reset all the motions and we'll come back here and we'll hear the motions on the interim orders, okay? But in the meantime, the interim orders still are in effect. Okay?
And even if my baby's safety is in, like, it's my
Mom,
baby's
another
safety.
judge already made the determination that your baby's safety was addressed. Parenting classes, short-term visits, longer expanded visits. And so at this juncture, I have orders I have to enforce. I don't have your signature on this, just so you know, counsel. I have to review this. I don't know what it says.
I'm
So-
happy to sign it, but.
Would you sign it? And I understand
I
you
just-
want it right now, but, and I'm gonna have to take a look at it. I haven't read it. But would you please sign that? And then I can always, where's your baby right now?
I just want to be really,
Home, okay.
And also, I don't want him to come to my house at all. I've asked the court many times if we can meet at a police station, because I just feel like it would be better and
You
safer.
could.
Yeah, I want that. The previous judge said that she didn't want, she claimed overexposure to law enforcement.
Well, I don't like it either, but, I mean, look, for everybody's, I mean, maybe even for his protection, that way,
there's a simple solution to this, Your Honor,
Yeah.
which is we can sign that pickup order and Metro can.
Metro will be there. I
They-
understand,
they-
but from,
No, no, I wanna be-
hold on. But Metro will only be there one time.
That's right.
And so the rest of their exchanges still need to occur. And so maybe we do them at the police station. And look, if she doesn't show up, then another pickup order would issue.
She is not going to follow your orders.
She-
Your Honor.
she may not.
I'm
She may
gonna
not.
object. This
She
lawyer
may not.
is
Hold
talking
on.
about me as
Hold
if he
on.
knows
Well, that's
me
what they
because he knows
do.
me.
That's what they do. They talk about, just like you talked about him, he's
Right, I
gonna
mean,
talk
but
about
I'm talking
you.
about plaintiff, not this
Well-
lawyer. I don't know him. You don't know me.
Well, that's his job. That's his job.
Doesn't know me.
If you had a job, or if you had a lawyer, his job would be to talk about the plaintiff. That's what they do. I
She
know,
had a lawyer
I know
till a
it's no
month ago.
fun. I get it. This process is not appealing. I get it. And it doesn't feel good to have someone saying things about you. I understand all of that. But that's what his job is. He's an advocate for his client. And he's trying to present to
We
me what
did
he
see
thinks will
this.
happen.
I'm gonna
and what your
fast forward
behavior
it
would be. Just like you're telling me
to here.
what his
A week
always
from
hold
Monday.
on. I can always give him compensatory time in the long term.
Yeah, we
I
saw it.
understand that. Thank you.
saw it,
Actually,
we
you
saw
know what,
it.
Counsel, would you do an order like with the dates in it and everything from today,
I can,
please?
absolutely.
Okay.
Beginning of 4/22/19. That's where we're
That's gonna
going.
be my order at this
In
point.
5,
So we will let you go.
4,
and we'll see you back here in
3, 2,
Okay. All right. Thank you.
1.
Thank you.
Cover for him. So I have to have this hearing, and okay, he did. All right. Still nothing. Okay. We are on the record in the Ravello versus Sandoval's matter, case D572482. We have the defendant present. We do not have the plaintiff, nor do we have his counsel. His counsel, I know you know, his counsel filed a request to continue due to religious reasons and what have you. I saw your
Yeah, you did miss it, didn't you, Fozzie?
opposition. We're going to call his office, see if we can get him. But he can't just tell me he's not coming. It was set today for this hearing, so we're going to call and make a record of that.
Does anybody know if 4/22/19 is Passover? Because he did tell her, I cannot be here for Passover. April sounds about right to me.
Thank you for calling the law office of Sean Lytle. How may I help you?
Hi, this is Judge Gentili. I'm calling from the courtroom, and I'm looking for Attorney Sean Lytle in a case that he has a hearing on this morning at 9 a.m.
Okay, let me see what I can do for you.
I'm sorry?
I'm gonna see if I can transfer your call.
Okay, please do.
May I please have your name?
This is the judge in Department F. My name is Denise Gentili.
Okay. And may I please have a good callback number in case we get disconnected through transfer?
702
And give me one moment while I try to transfer your call.
Okay, thank you.
Thank you.
I'm gonna get demonetized because of that.
This is April.
Hi, this is Judge Gentili calling from the
April, you're a hoe. That was my jam. I was listening to that.
courtroom. We are on the record in the Ravello versus Sangalaza matter. Is Mr. Lytle available?
No, ma'am. I'm sorry, but this is a Jewish holiday, one of the high holidays, and he has taken the week off.
Okay,
For
does he have
this
anybody
holiday?
covering for him?
No, he is a solo practitioner, and as he filed in his request for continuance, he is religiously obligated to take this whole week off for Passover. So he had requested a continuance until after the holiday.
Okay, well, we can't, I did not grant the continuance because, and I understand it's a Jewish holiday, but he should have someone that covers for him when he's unable to attend. So, what?
Sorry, Judge, but you're incorrect right there. You're not correct. He told you it was a religious holiday. He gets it off.
Well,
Well, what?
he was available up until this week. Unfortunately, there was this delay due to the request that was filed by the defendant
I
to
understand that, but he still needs to
have you
somebody-
disqualified. So,
I understand what happened, but he still needs to have someone cover for him. So I have to have this hearing, and I will notify him as to what my
The defendant tried to have her disqualified. Oh, yeah, that's right. But so this is the other judge back. This is confusing.
my decision is, but I have to conduct this hearing because I can't let it sit any longer. So, especially not until however far out it is that he was requesting. I mean,
it was 1 week.
No.
Sorry, guys, I have to tell you. This is the other judge. So he told the other judge, Passover, I can't be here. He didn't tell this judge. This is the other judge. Not the nice judge, right? This is a different judge, right?
It's
It
longer.
was 1 week, and his client has a right to counsel.
His client isn't here either. Nobody's here. And he's,
Right, his client was told not to show up to court without an attorney, especially with the shenanigans that the defendant has been pulling.
Okay, I understand, and I understand you're the staff and you're trying to assist Mr. Lytle, but you don't just get to not show up or have someone not cover for you. I mean, unless a request is granted to continue the case is on the calendar, and
Yeah.
so
We filed a request and we never received an answer. He has the right to request a continuance on. I mean, he did what he was supposed to do. He's done what he was supposed to do. Mr. Ravello has always done what he was supposed to do.
No. You're not here to argue the case. I'm just telling you.
No, I know. I'm just letting you know that
I know
there's
it's
nothing
not-
we can
look,
do.
Look, but
It's a
here's the
religious
deal.
holiday.
Mr. Lytle, as a sole practitioner, he has an obligation to have somebody appear if he's not going to appear as part of your licensing, and when you have an office, and as part of your insurance and all those things, you have to tell them that you have someone else that will cover for you when you aren't available. And
You've never had a problem with rescheduling for a religious holiday.
okay, I'm not
Ever.
trying to
This
look.
has never
I'm
been
not-
an issue.
I'm not. It's an issue because this situation has lingered, and it's important. And so, and I understand his religious holiday is important, but he should have somebody to cover for him. So, or be available by phone. I would let him appear by phone. So that I can just talk to
Well,
him.
if you want to hold, I'll see if I can get him on the phone. But again,
That'd be
his
great.
client isn't here
That's okay.
either.
He
but
doesn't need to be here. I need his attorney.
I'm
We
sorry.
should try to.
You just need his
I
attorney.
need
Okay.
his-
Can you hold?
I need Mr. Lytle on the phone, if you can get him on the phone.
No spoilers. No spoilers. I'll fill in for him. I'll be the lawyer.
This is Sean.
Mr. Lytle, we are on the record in the Ravello versus Sangalaza matter, and I understand that you requested for this hearing to be continued sometime after May 1 or later, but I need to have this hearing. So I already know what I want to do,
Okay.
but I just need your presence. And Ms. Sangalaza is here, and I just want to make a record and lay out what my thoughts are and move forward. So with that,
Okay.
and your client isn't here because, as I understand it, you instructed him not to come, but you'll just have to tell him what we're doing.
Okay.
So real quickly, last we were here was March 22nd when we had the hearing on the various motions, request for pickup order. Pickup order was issued on that date.
I feel like this is very illegal. Is this not very illegal?
Apparently that pickup order was not complied with. Second pickup order was requested. That pickup order was granted, or warrant was granted on 3/27. On 3/28, I guess the order was executed, or I don't know exactly, it was 3/27 or 3/28, but ultimately the court received notice of retrieval of the child on that date. On that
Correct.
same date, minute order for limited remand was issued, which was based upon what Ms. Sangalaza asked me to do, which was to send the motion to set aside back to Judge Marquis, who was the appropriate judge to hear the matter. Unfortunately, the entire case was reassigned back to Judge Marquis erroneously, which then divested this court of jurisdiction over the case. So we immediately notified the clerk of the court that was erroneous. And
Oh my
thereafter,
God.
on April 4, Thursday, we received notice of a new department reassignment, which was issued to have it brought back to this court. And then on 4/8, our office met to determine new dates to set Ms. Sangalaza's hearings again, back on this court's calendar. On 4/9, those notices were sent out. On 4/10, she filed a request to disqualify this court by requesting or filing an affidavit of bias. On 4/11, this court filed its response to her affidavit, and which, by the way, that affidavit also divested this court of jurisdiction to make any decisions or take any action. and on 4/17, Judge Bell issued her decision in this matter, which then denied Ms. Sangalaza's request to disqualify, and then we sent out this notice for this hearing so that I could reinstate and address custody, the custody schedule. I don't know what's been going on between then and now, but unfortunately, because of this, all of these procedural issues, we couldn't get you back in here. So, have you had the child at all?
No, I haven't. I haven't seen my child since
Okay.
the 25th
Okay.
when he was taken away from me
Okay.
and not returned.
Okay,
And
all right.
also,
Hold on.
Yay!
That's all I need to know. So you guys have a schedule. I told you the last time you were here you need to follow it. I know
And
that
I
there was a
did. I thought I
hold on. We're gonna follow it starting today. Mr. Lytle, Monday through Wednesday is mom's time pursuant to Judge Marquis' orders that were entered before I got this case. Wednesday to Friday, dad's time. And then alternating weekends. We're going to allow Ms. Sangalaza to retrieve her child today, but you're going to start following the orders.
and I did.
Oh,
I took
okay,
him to the
okay.
police station that Wednesday.
Okay, I'm just look. Again, all of this stuff happened, it caused this delay.
Okay,
I know
but
it's.
I followed the orders and you guys
I don't
helped
believe
me
that because
contact-
you didn't allow
I
the
was
child.
there. I have proof. I took
Okay.
pictures.
Ms.
the date of
Sangalaza?
everything. I
Okay.
was at the police
Ms.
station
Sangalaza?
that Wednesday with the baby.
We'll deal with all of that. I'm
And
just trying to
another thing
I don't have stop. I just need to get your time reinstated, okay? But you're gonna follow the order. You're gonna show up at the police station.
Which I was there.
Okay. So today, because it's already past the time for the exchange, Mr. Lytle, you're going to tell your client to appear at the police station at noon.
I need earlier because I have an 11.
If I can just jump in here, Your Honor.
Yeah.
So
I haven't
so
had-
part of the issue and part of why as of last, I want to say Wednesday or Thursday or whatever it was, I think that the next hearing we had was scheduled for next week, and so and the pickup order that we've been operating pursuant to gave Mr. Ravello sole physical custody.
So-
My understanding is that he went to Wisconsin for Easter,
Okay.
and I don't know that he's going to be back today by noon. I will make sure, I will find out and let you know. I know he's coming back, but his family is all there.
That's
So I know he went there for the holiday because he had the child.
Hold
So-
on. Your child's allowed to go out of state with you, and your child's allowed to go out of state with him.
No, he's not.
Yes.
There's a UJEA. We filed
They're
something.
not
that
allowed to
the child can't be
relocate, but they're
taken
allowed to go out of
state.
state for
Okay,
vacation.
I was not notified
All right,
of that.
they're allowed to go out of state.
I
Okay,
was not notified
Ms.
of that. I don't even
Sangalaza,
know where my
I am.
child, the address
You.
is.
This is the stop. Just stop. So you need to tell him to get the child back here if the child hasn't returned,
in the next
because
24 hours.
he knows that we are going to ultimately have a hearing on this. The child's not going to stay with him forever. He needs to bring the child back. If it's not back today, the child needs to be back ASAP. And as soon as the child comes back, she will commence her 2 days, and then they will alternate the weekend. This will be her weekend because she hasn't seen the child. Look, at the end of the day, the court, everybody knows my intent was for everybody to follow the order, to share the child. It wasn't to take advantage of the fact that all of these comedy of errors occurred, okay? So, at the end of the day, she needs to have her child, he needs to have the child. They need to share the
In the
child
next 24 hours.
per the order. So, you need to tell Mr.
Correct.
Ravello to have this child back ASAP, if not today,
Absolutely.
tomorrow. And then he needs to, do you communicate with him
No,
at all?
I'm not-
Okay,
I don't even know where he lives. He moved
okay.
and didn't know
Where's
that.
your client residing?
So he's still residing at the
I
same,
understand, but
at the same
apparently,
apartment.
his,
Got a new
Yeah.
moved he signed a lease on a new unit that's like 2 doors down on
Okay,
May 1st.
so
he
you
is-
need to do a
But
notice
it's
of
the same.
change.
It's the same building, same complex.
Okay, so you need
So
to
he is when he gets back, he is moving his stuff over to the new place.
Okay, so when your client returns, he needs to do a notice of change of address with in the system so that we know what his new address is, so that Ms. Sangalaza knows what his new address is, and this thing is going to get
Correct.
back on track. So these two are going to share this child. So Mr. Lytle, you're going to have to be in contact with, I guess, my law clerk, and then you're going to have to be in contact with my law clerk so that we can arrange when this child is coming home. So we know when this child is coming home. So we know when Ms. Sangalaza gets the child back. And again, this has to be done. If it's not going to happen today, needs to do it by tomorrow. She needs to get the time. And this is going to be her weekend. And then we're going to start next week. Monday to Wednesday is her full 2 days. Wednesday to Friday, are his. And then that's his weekend. And we're going to follow the schedule. And then we have hearing dates set.
And you
Down
need
the
to
road.
change the custody as well, because you gave him temporary custody.
I know, we're changing that right now. Right now. I'm putting it back to the old order. The purpose of that order is so that he can retrieve the child, because the
Okay,
child was...
but-
Hold on, stop. Just listen. You don't ever listen. So, unfortunately, what happened, I just laid out to you what happened,
Yeah,
okay?
you didn't serve me
Okay.
any papers.
Okay,
I
the
didn't
police
have
did.
access. And they didn't
Police
serve
brought
me.
it to you.
Police did not bring me any
Okay.
papers. You have no proof that police
All
brought
right,
me
well,
any papers.
the only way they could get the child is if they brought the order.
They didn't.
Okay.
I actually
All right.
took my child
Okay.
going on
Okay.
a normal visitation
It stinks
schedule that
not
was gonna
having
be
your
picked up
child.
on
I get it,
Wednesday.
Miss Sangalaza.
That's how it
Miss
happened. I don't know if this lawyer
Sangalaza.
lied to you and told you.
He didn't tell me anything. Miss
Okay.
Sangalaza.
I brought my child
Miss
for his normal
Sangalaza.
pickup, and you held me in contempt for something
I
I
didn't
didn't
hold you in
do.
contempt at all. There's no contempt. What I'm telling you is that the order is entered so that they can take the child and let dad visit with the child. And then you were supposed to come right back in here. But unfortunately, all of this stuff that I just laid out happened.
Okay, the error
Okay?
is not on my part.
I know,
Yes,
I
it's
know it wasn't
on
on your part. I get it. And look, I also understand that if you don't like not seeing your child, I felt for you during all this process. I kept wanting to get you back in here. But that's also how he feels. So you have to understand, you need to comply with the order, because if you don't comply with
And
the
I
order,
did.
listen, if you don't comply with the order, then that same order has to be issued again to get the child back. And I don't want to have to do that. You don't want to have to go without your child.
No,
nor does
something-
Mr.
Okay, something
nor does
is
Mr.
going on
Ravello.
that's not right. How does my child leave state?
You can take the child on a vacation, and he can take the child on a
With
vacation.
no notice?
Yeah, of course.
Okay, so I'm definitely.
So you're
take my
gonna,
child with no notice.
all you have to do is give an itinerary. Now,
No,
because he
and
had,
didn't give me, and I didn't get anything.
Ms. Sangalaza, it's because of the way the order was
No.
drafted, he didn't give it to
No,
you.
he's still my child.
I understand that. I understand that. I don't agree with it. I don't agree with it. Just because he had sole legal and sole physical, I don't agree with the fact that he didn't give you notice, but it sounds to me like you two don't communicate.
We don't.
Okay, well, you're gonna start. You
I
have
mean, I
to.
can't communicate with someone who is constantly lying to me
All right.
and writing
right.
messages that
Okay,
are just
we're not gonna-
very
we're not gonna-
inappropriate.
Okay, we're gonna reinstate the schedule. Mr. Lytle, you will contact my office upstairs. You will speak to Cami Ha. You will tell her when your client is returning. Cami Ha will contact you, and she'll let you
guys
know
have to make
when
sure
the
you
child's
contact
returning.
me. 'Cause
Pardon me?
last time, you have to make sure you contact me, because last time you said you were gonna contact us with something. I
Stop
never
it.
got any
Stop
call.
it. Just please listen. I'm trying to tell you what's going to happen. Mr. Lytle is going to contact our office. He's going to tell when Ms. Ha upstairs when your Mr. Ravello is returning. Then she's going to let you know, and we're going to arrange a time for you to pick up your child. So, Mr. Lytle, you need to make sure that that happens. You need to let them know when, in fact, this child is back here. If it's today, you need to schedule a time for the child to be returned to mom today.
Maybe they should just meet at the hospital to exchange the child, as the judge called it once. That way the mom can take them right in.
If it's not today, it's tomorrow. It needs to happen ASAP. She needs to get the child back. And then, this is going to be her weekend, like I said. Then we're going to start the Monday to Wednesday, Wednesday to Friday, alternating weekends. And this is going to stop. Okay, I have to start another trial. This is the order. My office will arrange that with you and Mr. Lytle so that occurs. He's going to let us know.
Am I gonna call before 5 p.m.? Am I gonna get a call before?
We're gonna
5
get,
p.m.?
as soon as he tells my office, you'll hear. I can't orchestrate this. I'm just telling you that he's gonna contact my office and they're gonna work with you, because that's all I can do. Mr. Lytle, your job is to get on that ASAP.
That'll be my next call, Your Honor.
Okay, thank you. We're gonna go off the record. I have to
Thank
start
you.
the next trial. Thank you. Okay.
All right,
we're gonna go
take
off the
care.
record.
Have a good day, folks.
Thank you.
Have a good day, folks.
Okay, we are on the record in the Ravello versus Sangalaza matter, case D 572-482. Mr. Lytle, are you there?
I am here.
Okay, state your appearance for the record, please.
Sean Lytle, 11640, on behalf of Nicholas Ravello.
Okay, and Ms. Sangalaza, are you there?
Yes.
Okay, so we have both parties on the phone. Mr. Lytle, could you update us as to the status of your client's return of the child?
My client is on a flight that lands Friday morning at 8:48 a.m. That's the schedule.
That's unacceptable. That's unacceptable.
Okay, Ms. Sangalaza, just hold on and let me hear what he has to say, and then I'll get your response. Hold on. He's on a flight what now?
He's purchased tickets on a flight that arrives on Friday morning at 8:48 a.m. And then he's going to take the child straight from the airport to Metro for the exchange. So I would assume that's going to be about 9:45. I mean, I'm not sure how long it's going to take to get off the child with or off the plane with a young child, but I would, he's going to go straight from McCarran to the Metro headquarters on MLK. And so I would think it would be 9:45. I think the best plan would probably be for him to text or call Ms. Sangalaza, as soon as he departs the plane, and then they can head straight there.
No, this is unacceptable. My child was supposed to be here today, the latest, this morning. I'm not waiting until Friday to have my child returned to me. You better call your client and tell him to get on a flight this very minute. I'm not taking
Okay.
it. Judge, you cannot say anything about this because
I can
you
say
said it
anything
in
I
court
want
on the
about
record
this, and we're going to
yesterday
hang
that
up
my child
on
was
you
gonna
if
be
you don't
returned to
stop.
me the latest tomorrow.
Okay, I'm in charge because none of you can
You're
listen.
a liar. That's what you
None
are.
of you can. Okay, we're going to hang up on her shortly, but I'm going to tell you right now what the order is, okay? Mr.
No, you
Lytle,
cannot change the
Mr.
order that you said
Ms.
yesterday. I have people
Sangalaza,
listening.
Ms.
I have people
Sangalaza,
listening to this
stop.
call.
Stop. So here's what we're going to do, because you can't talk to people respectfully. You're going to
No,
keep your mouth.
you can't
We're
be
gonna
respectful
stop.
to me because you said something in court.
Stop. I
and now you're taking
ordered
what's
Miss
before your head.
Sangalaza. Stop. So I'm going to give you compensatory time for the time that you just lost, because I ordered him to be back by today.
No. You need to also hold
Listen.
them in
Stop.
contempt. You need to.
I know exactly what I said. Please stop. So, I ordered yesterday was to be the turnover until I realized he wasn't here. Then I ordered, if he can't be back yesterday, he should be back today. He's not back, but you're missing Monday to Tuesday through Wednesday. So, that's 2 days. So
No.
Stop! So now...
No.
Stop!
Remember what you said, that I was supposed to have my
I
child
know
back
what
by
I
today.
said.
I don't understand. And you last time you hastily signed
What
an
is
order.
wrong with you?
Listen to me. You hastily signed an order for my child to go with him. And I filed an order today that was going to have police.
You know what?
and
Go
authorities
ahead. Go try to
assist
find
me-
him in whatever state he's in then.
Assist
You know
me
what?
in getting my
Listen
child.
to...
You're biased. You're
We're
so
hanging up on
biased
her.
that you can't
Here's the
even
deal.
do your job
This is my
correct.
order. I'm going to state it out
And
loud.
you're very
and then...
racist.
Miss
You're
Sangalaza,
very
stop.
racist.
Stop.
You're very racist and biased.
Oh my God.
Clearly.
Seriously. So here's my order. The child is going to be returned to, if he's on a plane at 8:48 a.m. Now, Mr.
No,
Lytle,
my child is going to
stop!
return to me today.
Oh my goodness. I'm
I'm
going to get
not
off the
taking
bench. I'm
Friday.
going to hold.
I'm not.
Leave her sitting
I
there.
took myself to court yesterday,
Oh.
and you made an order, and you cannot change that order. Absolutely not. I showed up. This night.
Put her back on. Say that again. I'm sorry.
You're
Go back.
racist and biased. You're harboring a criminal just because he's white.
Harboring a criminal.
Last
Stop.
time you didn't serve
You
me papers,
had
and
a
you
baby
hastily,
with this
as
man.
You stated in your
You
affidavit,
had a
hastily
baby.
You hastily signed an order to have authorities come and take my child away from me. But now I filed the same exact order, and you're so biased you can't even give me the same treatment that you gave this attorney because he's white and his client is white, right?
Really?
Because you're
Okay.
very racist and very biased.
All right. Okay. So now that you've made your point, here's what my order is.
And that, yes, my point is the honest truth. I did everything by the book. I filed my motion. I wrote my order, and you didn't give me the same exact treatment you gave him. You're going to have to explain to FBI. You're going to have to explain to Chief Judge and the Commission as to why you cannot. You're so biased that you can't even
Correct.
do
Me
your
and
job
Judge
correctly. You
Markey
can't
both,
be
right?
fair. My request is for you to recuse yourself because you're so biased you can't do your job.
Okay, so here's my order. I see that you filed your ex parte motion for return of child. You also filed the order before the judge had an opportunity to sign it, so.
I am
that-
supposed to file the order so that it can go to you to get signed.
No, that's not how it works. So you
That
actually.
is how it works. I read the instructions.
Ms. Sangalasa,
You know what? Why don't you
keep
stop
cutting her
telling me
off,
how it works?
Okay?
Well, because you clearly don't know how to do your job.
Correct. Yeah, sure. Okay. So, and you know how
Yes,
better.
correct.
Okay.
Right,
Stop.
you know how to do
Please
your job.
stop. Please listen to me. I'm going to give you compensatory time because let me explain something to Mr. Lytle. What I
I'm not even mad at this batshit crazy woman screaming at this judge right now. I'm not even mad at her because she should have been in contempt a long time ago. This is the judge's fault again. The judge is letting this happen again. Different judge, same thing.
don't appreciate is that your client took advantage of the situation because you know I ordered that I signed the first order thinking that she was going to turn over the child and she did not. The second order was signed so that I could get everybody back into court immediately and then reinstate contact. Instead, this time period lapsed. I need to get contact reinstated. Two wrongs.
No. You cannot cover your own tracks. What you did was wrong. You didn't serve me any papers. You wrote in your affidavit that the reason why you hastily signed his order was because of some wording. And yesterday on the record in court, you claimed that the police were supposed to serve. Well, actually, no, you claimed that police had served me papers, and police hadn't. You have no proof. If there was an officer who was to serve me papers, you should have provided the name of that officer and their officer number, because
All right,
to
okay,
be honest,
okay, Ms.
you're saying
Sangalazzo,
no.
please
You
stop.
do one thing and you
Oh,
say
my
one thing and you
goodness.
do the exact opposite.
Okay, fair enough. So let me
You
make
wrote
my...
right in your
Stop.
affidavit, and then on the record, you're
Stop.
caught lying. You're
Oh, my
a
goodness.
liar.
Do you want to
And
see your child or not?
I have no trust. I have no trust in you as a judge whatsoever. I don't want to
You
go
don't trust
before you
anybody,
anymore.
apparently.
You need to recuse yourself. I'm tired of your lies, and if you have an opportunity. You have an opportunity to admit that you're biased and to admit to ex parte communication, yet you won't. And once it backfires in your face, it's going to be too late.
Okay, so here is...
Your Honor, if I may just since we are on the record, I just want to make one point, which
really
is...
yeah.
I know,
No, let the judge talk. You're not making any point.
Oh,
Let the judge-
Ms. Sangalazzo, let me explain something to you. You're not in charge. And if you continue to act like this, you're going to be held in contempt.
No, this is
Oh, my
this is
goodness.
about my
Yes,
child.
exactly.
This is
You're
about
not in
the
charge, so let me
safety
talk-
of my
let me
child.
speak.
And you guys have played way too many games with me. You guys have played way too many games with my child. You put him with a stranger, someone who literally ran away from him when he was born. And all of a sudden, after I've raised up my child by myself, was not compensated for all of these months, he comes and says that he wants to take my child, and you give him my child. So therefore, I have a right to say whatever I want to say. I'm very angry with you. The fact that you guys will just take his side. I'm an African American woman. I'm a black woman, and you guys are all.
I have to say something because no one's allowed to type it in chat because the mods will get really mad. But Fozzie nailed it. Holy fucking shit, this is awesome. I just said what everybody wanted to say.
White. You can say you're not racist as much as you want until you're blue in the face, but your actions say otherwise.
Okay.
And it's clear that you don't have children yourself because of the decisions that you make.
Okay, so here's what I'm going to say. So, Mr. Lytle, I want to make sure that I reinstate her contact, and we're following the order that was entered by Judge Marquis.
That's what you said yesterday, and you didn't
And listen
deliver.
to me.
You didn't deliver on
I
Ms.
that.
Sangalasa.
You're going to
you
be
keep
held in contempt, and the next time you...
keep interrupting what
Held
the
in
judge is trying to
contempt
say to
for
Mr.
speaking.
Lytle.
I'm a pro
You
se
had your
litigant.
chance to
I'm a pro
talk.
se litigant, and it's my
Okay.
right to
Oh, my
speak.
goodness.
As a judge, you have no right to shut up a pro se litigant, and that is in the Constitution, the Nevada revised statute.
Okay, all right. So we're supposed to just let you talk however long you want.
Yes,
Okay.
as a pro
All right,
se
so
litigant,
here's the
I'm
deal.
not represented by
Here's the
any
deal.
counsel. I have
Ms.
the right to speak.
Sangalaza, we're gonna. I mean, I've let you go on far longer than I would let anybody else. And so here's what I'm gonna say. You're gonna get compensatory time for the time you just missed this week. Now, this is what's gonna happen, Mr. Lytle.
It's not just
Mr. Lytle.
this week. It's a whole month. I
Well,
have not seen
he
my
lost
child
a
in
lot of
month.
time too. We'll deal with the
No,
lot.
no. It's a
Hold
whole
on.
month.
Stop. I will deal with the compensatory.
You took away my right to breastfeed my child. It's been more than just a week. It's been a
I
month.
understand.
I just
I
no,
understand.
you don't understand. You can't say you understand and you
Okay.
say the exact opposite. I'm not taking this.
All right. So here's what I'm going to do. I'm going to tell the order. So here, I understand you've missed time, and I understand you are entitled to compensatory.
You don't
time.
understand.
I do. So
No.
here's what. Listen. So for this week, the compensation is going to be as follows. On Friday, she will receive the child. Let's say 10 a.m. And that's going to be at the police department, and that's on MLK. Correct, Mr. Lytle?
Yes.
Okay.
Can't be at
No,
court.
no.
Yes.
He gets, so Nicholas gets
All right, I'm
allowed
just going to issue
whatever
a minute
he wants.
order because
My
you're not
child.
listening.
My
I'm just
child.
going to
I
issue a minute
understand.
order because you're not
And-
listening.
and-
We're going to
and
hang
now-
up, and I'm going to go off the
without
record,
my
Mr. Lytle. That's when you should
without
have your
my
client
permission,
back.
And now I'm held.
And that's the
Okay.
date and the time.
And you
Thank you
wanna
very
hold-
much. We're hanging up. Goodbye. Courtroom, it's about how you handle yourself in the courtroom. You two know how it's supposed to be done. Sometimes the litigants don't, but they're vested with the same obligation to conduct themselves like everybody else. I just want her to understand that I've been very patient. A lot of people would not have been that patient. A lot of judges would not have been that patient.
And I've also been very, very direct about the need to follow the court's orders, regardless of whether
The other side.
you
does.
think that they're, well,
Oh,
whether the other
regardless
side's
of-
following them,
oh.
or whether
She
you
got a
think
lawyer.
that
She
they're
got a
right or
lawyer.
wrong. They are the orders of the court.
Right.
And I did have that conversation, even prior to,
Okay.
when I first learned that there had been some issues. So
Okay.
she's well aware that court orders are court orders, period.
Okay.
And they need to be followed.
All right, very good. I'm sure, I know she understands. Okay, so with that, first things first, paternity test results. Ms. Sangalaza asked for paternity testing last time. We sent everybody down. The results are here. I have them ready for you all to take your copy. So each of you need to sign for it.
And we
The-
affirm?
Yeah, and the findings are that there is a 99.99% probability that Mr. Ravello is the father of Julian.
You know what that means? That means the price that he paid for this paternity test is going to be taken out of her child support if and when she gets it.
So those have come back, Ms. Sangalaza, with a positive result. So the next issue.
Just on that, before we move on
Mm-hmm.
from the paternity test, I believe that this court's order was that, assuming they were positive, that my client would be reimbursed for his share of that test because we
Oh, I split it, didn't I?
yeah,
Yeah.
so,
I just said it was subject to retax, yeah.
right.
Yeah, so, and how much was the total test?
He paid $90.
90, okay, oh, that's right, it's 190, okay. All right, so the next, yes, sir.
Also, could we just get documentation of what he paid? Just for proof.
Yeah, I'm not gonna deal with it right now, what I'll do is I'll encompass all the financial issues together, like, we'll have that all at the trial for the most
Okay.
part. We can address all of that together at
That's
one
fine.
time. Yeah, I don't, it'll get handled.
I had that question what Mr. Lytle is telling the court, we just would like some documentation.
Sure, no, but I can't imagine you didn't pay it, otherwise they wouldn't give me the test results. Did you pay 90 as well?
No more.
You paid more? What'd you pay?
I had to pay for the baby 90 and 60 for myself.
Oh, that's right, because I think I made him pay his share and then you paid both other two pieces. Okay, we'll deal with it when we go to the trial, so we can address all the financial issues. So let's talk about the first
Damn, he's not getting it. She's not going to give it to him. Ah!
motion that she filed. That is the motion that was filed on 3/26.
Motion to modify.
Pardon me?
The motion to modify?
Yeah, motion to modify. She said she's seeking for legal custody to be changed to sole legal custody, alleging father's incapable of providing basic necessities for the child, doesn't have the child's best interest in mind, knows nothing how to care for the child, and that physical custody should be changed to sole as well. And then this is basically the same allegations were made in this motion that were made in the original motions that were heard by Judge Markey. And I understand that these are her claims that she thinks are a basis for him to not have joint custody and wants to have sole physical custody, but they've already been heard. And the court's already made orders that kind of set the interim plan in place. Yeah.
It's my
You're
understanding,
late.
Your Honor, that
You
Judge
missed it.
Markey didn't look at the exhibits that were presented. That's my understanding. I have no proof of that. But there are issues. I mean, I submitted a supplement,
I saw it.
and there's cleanliness issues of the child coming back from dad. There's rashes that he comes back every time with a rash. There's issues of
Okay,
the
so-
the child's 1 year old and 27 pounds and is in a forward-facing car seat. There's a photo of dad putting him in a forward-facing car seat.
Mm-hmm.
When a rear-facing car seat is the appropriate car seat for a child up to 2 years old.
I mean,
There's dad's criminal history,
yeah,
which,
I see that one. When is that picture taken though?
when was the picture taken of him putting in the car? Just this past week, Your Honor. I mean, these are where the concerns come from, because obviously, the court has already talked to him about having an appropriate car seat back in December.
Both of them, as I understand it,
Correct.
yeah.
And yet still we have a picture from just last week with him putting the child in a forward-facing car seat.
Yeah, why is he doing that? I don't know, I mean, I don't know off the top of my head whether he should be
Yeah,
backward facing. I think he should be. This,
We've already talked about it. I mean, I guess the issue, he's kind of a tall baby, so he's going to flip it back around. It was just a mistake of his understanding. He thought he seemed to be outgrowing the rear facing, and so he flipped it around for a couple trips, but he has turned it back around now, and
do you know when,
so.
off the top of your head, when the rear facing is supposed to be turned forward?
2 years old and at least 30 pounds. And
2 years and 30 pounds, so he's not quite there yet. Okay.
I think he's close to the 30 pounds, and that was the confusion.
Okay, so let's make sure everybody
Yeah.
is on the same
Yep.
page, all right? 2 years, 30 pounds.
Yep.
He's not 2 years old yet, clearly. Big kid, sounds like, because if he's 27 pounds already, he probably sounds like looks like he's a big boy.
Yeah.
But nobody's to put him in a forward-facing car seat until and quite frankly, what you probably should do is both agree when you're going to do that.
Correct.
That
Size,
way
not
everybody
age.
is on the same page. I mean, if he just meets 30 pounds, maybe it's still wise to keep him backward facing. Or I don't know if maybe the experts say once they hit a certain weight, it's better for them to be turned around. That I assume you probably have done the research on it. Yeah. What do they say? Do you know?
2 years and 30 pounds.
And 30.
Yes.
Right. So he needs to be 30 and 2 years old, or does he need to be either or?
Both.
Both. Okay.
So it would seem to me that even if he's over 30, but he's not 2 years old,
He
he
needs to
still
still
needs
need to be facing backward. Okay, so Dad just
Yeah, we'll use the rear facing.
just
No
just
problem.
do that.
No problem at all.
Okay.
you know,
That's going to be the order.
and,
Okay.
his criminal history out of Wisconsin is a concern. I mean, the argument's gonna be that it's old, but it's still, I mean, it's concerning. We have drug use, or drug possession, we have domestic violence.
Yeah, you're going to raise all these issues at the trial, correct?
But these are also part of the issues that, support the motion to modify. The other issue is the TPO that her dad got. One of the allegations was he was walking around like he was on, quote unquote, Dad says that he was acting like he was on something, which makes us wonder if he's still using drugs.
I'm going to object to any testimony about this TPO that was actually stricken in a separate hearing over in Justice Court.
Like I say, I don't know. I know that it existed, but I don't know anything about what happened in that.
But it's his exhibit to one of his motions, or to one of his
Well,
oppositions, so I think.
right, saying
to
she
have
they
him
applied
say-
for it to try and stop him from having contact.
No,
but it was
no,
ultimately.
the dad did.
I
And
know.
but
But it included everybody in the household, and that's what stopped contact from happening.
But I'm just saying that it's a pattern of, his behavior and his aggressiveness that's concerning. That's what I'm saying. He shows up, he's banging on the door,
Well, now we have orders in place where they don't go anywhere near each other. I mean, since, look, I looked at the whole history. I know Judge Marquis was like, these two will have no contact. They will meet to
Understood.
exchange. That's it.
Your Honor.
She made him jump through many hoops.
I'm just trying to make my.
And make your record, I understand, she's filed her motion, and I'm saying, based upon what she's filed, I understand that those are her complaints, but the judge before me said, I've heard these, I'm ordering him to do some classes, I'll deal with that issue, because I know she's raised it. She was ordered to do some classes as
And
well,
I'll address that, and I need to address that with the court, because there was some confusion on her part.
as to whether it was her or him.
No, as to well, we can get there when we.
Okay, all right, that's fine. So this one in particular, basically, again, requests kind of the same relief that she's requested in the past with the same factual allegations. So what I think needs to happen is that all of this, coupled with whatever other information they intend to raise at trial, will be addressed at trial, and we'll talk about trial date when we get to the end of the hearing. But to modify at this juncture, based upon sort of the same, again, most of the same allegations that were already raised and have already been heard, and temporary orders already entered, I am inclined to deny that request at this juncture. Now, I mean, and I'm not trying to invite litigation, but look, part of this, if there's a diaper rash, they need to talk about it. I mean, this is not the first person that's come in here and said, hey, I get the child back and he or she has a diaper rash.
Every time.
They need to talk about that.
Okay.
So she's had him for a year for the most part, and she knows best what he needs. So that should be a communication issue. Like, hey, I've learned that, when our son is getting a diaper rash, this is what helps him, or this is what causes it. And so maybe, as opposed to just saying, you figure it out, and now I can say you don't know what you're doing, they really need to start communicating about those things, which I think Judge Marquis also said in some of her hearings, that, this is going to be an exercise in these two learning to communicate, because it's the best for their child.
I understand.
Yeah.
And then there's just one other issue is, there was an order, I'm sorry, I don't recall the date off the top of my head, where he was to go to a doctor, find out what formula was best for the child. He's never provided that information, he's never provided any proof that he went and found out, and her thought is maybe whatever formula is causing the rash.
Might be allergic to it or something.
Correct.
Is
So,
what you're thinking?
I mean, we would just ask that he provide that information.
How would you know that though?
The order actually was that if she wanted him to use a particular formula, that she needed to identify that. And
I
then
read
he would
that.
comply with that dictate. Instead, the response was always figure it out, essentially. And so Judge Marquis had said, if you're not gonna tell him what formula to use, then I'm gonna let him use whatever formula in his judgment he thinks is appropriate. And that was the extent of that conversation. So,
But I think, if I recall correctly, I believe there was also, he needed to go to take the child to the doctor and have a doctor determine what formula would be best as well.
I'm gonna go with, I think that, hold on one second. I'm trying to read this, and it's really small. Hold on here. It says, defendant has to name a formula if defendant wants to provide, okay, so this is about the formula issue. Defendant wants to provide breast milk for plaintiff to give to the baby. Plaintiff is to use that first before using any formula supplement. If the baby is not assigned to a specific pediatrician and plaintiff wants to take the baby to see one pediatrician, location close to his house, court will allow something. I can't, it's too small. Hold on one second here. Holy Moses, what just happened? Sorry, it jumped on me.
Absolutely. Thank you, Brick
Well,
in the Wall. Thank you.
this, but plaintiff needs to give defendant notice in writing of the name. If there's a cost associated with that doctor, plaintiff will be responsible for the copay 100%. Plaintiff may follow the pediatrician's recommendation about formula, supplements, eating schedule that is appropriate for a 9-month-old and what types of foods the doctor would like the baby to eat. Doesn't say had to, doesn't say
That's,
required to. It was, she should let him know, and then,
well, she doesn't use formula, so she doesn't.
okay, but I think I'm speculating because I wasn't the judge, but the judge was probably giving her the opportunity to choose what she thought was best, and if she didn't, then he was gonna be able to do whatever he wanted. So, and if she wants to weigh in, I mean, I don't know, do you know, what are you feeding him now?
In terms of formula,
Is there formula and food, both?
Enfamil brand formula,
Infamil?
fruits, vegetables, meats, non-processed foods,
Okay.
yogurt. We got a whole bunch of fun foods that I like to eat at the high chair.
Okay. All right. So, are you familiar with that formula? I mean, I assume how often is he even eating formula at this point?
He
Or
uses
drinking
a bottle before
formula.
every nap and before bed.
Okay. And then between you're feeding him regular food.
I give him a bunch of food. If he wants to eat, he eats. If not, we put it away.
Okay.
Are we talking baby food, Your Honor, or are we talking throwing a steak in front of the child? I'm a little confused when you said he's giving him meats and vegetables.
It's probably,
We're not talking throwing any steaks.
we're talking baby food,
We
right?
chop the food up into very small parts.
Well, you might need to
Year old.
puree some of it. Pardon?
He's a year old now.
There's purees and baby food involved.
Mm-hmm. Okay. All right. So again, you two should be communicating about this. Are you using a communication program or no?
Talking.
They are using Talking Parents. Okay. That's right, as I read Talking Parents. Don't mind me. All right. All right. So on the 326 motion, I'm not going to change legal or physical custody now, based upon the allegations in this motion. But again, these are just temporary orders. I don't know what's going to come out at the time of trial. We'll make that determination when we get there, as to what's in the child's best interest. Then there was motion for order to show cause on 328. There was one issue with regard to the certificate of completing the parenting class, which Dad was ordered to file and serve the certificate. Last we were here, when Mr. Ravella was here, Ms. Sangaloza was here, we asked about the certificate, and he provided me with a picture on his phone of the certificate. But I don't know if he has the certificate. It's supposed to be filed and served.
I believe we did that.
I don't see
I
it
didn't
in
see
the
anything in the
record.
If we did it,
You
then
didn't.
that's on me, and I will get it into you today.
You didn't.
We have it.
You have it?
Yep, absolutely.
Okay, I mean, I saw it,
Yeah.
and just so you know, it wasn't like, it was actually a picture of the certificate, so there was like a desk around it. I mean, it was like a folded up, opened up certificate. It wasn't like he took does that make sense? It wasn't
Yes.
like the whole screen was filled with a certificate. I actually saw a picture of the whole certificate.
That's fine,
If that
yeah.
makes any sense.
And that's
So-
like I said,
Pardon me?
if they file it, that's fine.
Yeah.
I just haven't seen it, so.
Okay, I saw it. I saw it last time. Okay, and Mom was ordered to take classes, nurturing parents and families.
This is where the confusion is. She didn't know where to go. She thought the court would provide her with some resources as to where to go.
It's through the county, I believe,
Okay.
and
So-
it's free, I believe, too. Do we have a class? I don't know where that is. It's probably out in the hallway.
She's willing to take it, she just didn't know where to go or how to go about doing it, so.
Hold on one sec. We'll find that out for her right now.
She couldn't ask anybody?
So the parenting project, I believe that's who it's through. Hold on here. Yep, here it is. So, it's called the Parenting Project. If you run Clark County Nevada.gov or ClarkCountyNV.gov, but if you type in Clark County Nevada parenting classes, this comes up for the Parenting Project, and it has all the different classes. I think that might have been the same thing he did. Can't remember which ones he was.
And what was the name of the class again?
Nurturing Parents and Families.
Nurturing Parents and Families, okay. I'll find it, Your Honor, and I'll pass it along to my client, get her to take those classes.
Okay. Hold on one second, let me see if I can.
And she can't see the child until she takes those classes.
I'm gonna print this page if I can. Hopefully this gives you, at least it gives you the phone number. Classes are free, so that'll give her that, and she can take that.
We'll get that,
She can-
we'll get the certificate.
Okay, and if she can just do that within the next 30 days, that would be wonderful.
Isn't it 6 classes?
I don't
I thought,
think so. Oh, no, I mean, however many there are, I'm just saying get it started.
started,
Yeah,
yeah.
get it started within the next 30
Understood.
days. I don't know how many there are in the Nurturing Parents and Families. There might be 6. There's usually several weeks of them.
understood.
But within the next 30 days, she needs to get started, because unless it's not offered, I just don't know. As soon as it's offered, she needs to get started. Because I know they have them only certain periods of time. See the numbers on the top there? So she can call them, okay? She seeks lost wages due to the order that I entered. But it's not really an order to show cause scenario, so any of these financial issues, I'm gonna just defer them to trial.
Yes, ma'am.
If she thinks she's entitled to something, and you need to discuss that with her
I
about
will.
whether she is or is not, and whether she wants to make a claim, but I'm not gonna rule on anything today, I'll just defer any of the financial issues to trial.
Understood.
All right, and then on 4-8, the motion, she said that Dad failed to disclose his address as he was ordered to. And now, as I understand it, Dad may have relocated, and now we don't know where he lives. And
Yeah,
so-
and this was an issue, this was one of my exhibits, is she asked him for the address, for the apartment number. He refuses, he says, I'll give it to you if the judge orders. Well, the judge already ordered.
Right, I saw that.
So,
So yes, so here's the deal.
He's in the same complex, and
He just needs to tell her, look, here's why that is necessary. Because if he calls and says, we have an emergency, and I need help,
yeah.
she needs to know where to go. So that's why the court ordered that to begin with, and so I'm gonna tell him right now to state on the record what is his address, and if he relocates again, he needs to immediately, within 1 week of knowing where he's going or relocating, he needs to do a notice of change of address with the court so that we know where he is, because we all need to know where his address is, but Mom needs to know, because when the child's in his care, they may need each other's help.
Right.
And he needs to know where she is too.
And just to be clear, when that motion was filed, he did not have a new address. So
Okay.
I mean, that was the thing.
All right.
So,
Well, now I want to know what his new address is.
absolutely.
So what is it?
Go ahead, tell.
2664 North Buffalo Drive, Unit 2419.
Okay. Okay, so we're gonna have him do a new, a notice of change of address form. And Ms. Sangalaza, just so you know, we sent you mail from here and it came back, so I wanna make sure we have your proper address as well.
yeah, the other issue we have is, I guess when there was a welfare check by the police. The police said somebody else is living there, they couldn't tell my client who, so.
So living where?
With him. She doesn't know who lives with him. I talked to Mr. Lyle, he said nobody does, but that's not the information she got from the police when,
Okay,
So-
all right, hold on, let me, one thing at a time. So I was asking, what's her address then?
At 5086 Penryn Court.
Las Vegas, 89139?
Yeah.
Okay, Penryn, correct? Okay, so we have case correspondence to a Buffalo address, which probably is the old, it's 2656 North Buffalo, apartment 1232. Were you ever in that apartment? Okay, so that's not where you want it to be sent now. Would you change that for her, please? All right, so, all right, hold on 1 second. I want to look to see what we had in terms of the return from Karen. Okay, that's fine. So it said case correspondence address in our system was the Buffalo Drive address, and so when we sent you mail, it came back, but now we won't send it there anymore. We're changing it so that it is just the Penryn address. Okay, all right. So who lives with everybody? So like, who lives in your house?
Me.
Me and your child, right?
half the time.
Who did the police see there then?
I think they went to my old unit.
Oh, they may have.
They met the new tenants.
So she knows what the new unit is?
This was prior to his move.
Oh,
I was in Wisconsin,
when the well check was happening?
I think so.
Do you know when the well check happened, Ms. Sangaliza?
Yeah, it was the week after, it was the first week of April. They saw him and someone else.
They spoke with him and there was someone else there,
Okay.
according with the police.
There was a time when police came, my friend Mike was at my house.
Okay. Did he live there?
No, he was just visiting.
Your friend Mike, like, does he live in Las Vegas?
He's from Wisconsin.
All right. But you're stating right now, no one lives in your house with you but you and Julian. Not that you're not allowed to have someone to live in your house. I just want to know who lives there. You're allowed to live with somebody. That's not
Since I take care
prohibited.
of this 1-year-old by myself, sometimes I invite friends over.
Mhm.
He happened to be over when the police stopped by.
Okay, I'm again, answer the question. Is anyone living in your house right now with you besides Julian when he comes over?
No,
Okay. Again, you're not prohibited from having someone live with you. She just was curious if there was someone else living there. Who are you living with?
My mom, my dad, my sister, me and the baby.
Okay. All right, so everybody knows who's living with whom at this point, all
We
right?
have reason to believe
Um,
that her brother is also living in the. Can she confirm or deny that?
Brother's not living there?
Barrett Sangalaza?
What's his name?
Barrett
Barrett? Where does
Sangalaza?
Barrett live?
He doesn't live with us.
Where does he live?
He has his own place. I don't know where, but he has his own place.
Well, he's under house arrest at her address.
He's definitely not under, he's not there, so, and I don't even know how they would even.
Why is he under house arrest? Does anyone know?
I don't even know why they would speculate that, so.
We didn't have to speculate. We were at justice court on the TPO. His was the next case, and we got to hear all about it.
Oh,
So,
okay. Well, I don't know. So you're saying he's not there? All right.
so her answer for the record today is he does not live in
Barrett
that
doesn't
address.
live there. Okay.
That's all. That's fine.
All right. And Barrett is your brother? Okay. How old is he?
He is, oh, I'm sorry, I have so many siblings. He's 31, I think, 30, he just turned 31 this year.
She just lied and got her brother rearrested in one foul swoop.
Okay. I think I've addressed all the issues that were raised in her motion. I'm not going to issue orders to show cause on the issue of the address because we've addressed it, and the whole purpose of contempt is to compel compliance. Look, y'all need to make sure you exchange that information whenever it changes. You just do it in talking parents and do it with the court because we need to know where everybody is. Because if we're going to send mail, typically we'll send it to counsel, but if for whatever reason counsel's not on the case, we need to be able to send it to you. So I just need to make sure everybody updates their information.
I just have one other issue I'd like to address.
Sure.
His FDF.
Oh, yeah, for sure. So I had ordered him to have an updated FDF by April 15 with the additional information that I did.
Okay.
I did. And she's right. I ordered
Our
that.
concern is that his FDF, he claims $1,850
No, I know.
worth of income, but $6,300 worth of expenses.
No, I get it. And I told her last time, and I ordered him to do an updated FDF, and I think I ordered both of them actually to
Financial disclosure something.
Hers hasn't changed, so.
But in any event, Judge Marquis and I both said, I mean, we'll ultimately deal with adjusting of child support if we find that child support was improperly ordered. That we would just make up the difference at the time of trial. But part of this is going to be a discovery situation where you're going to have to request. I mean, under 16.2, they should produce whatever they have that complies with
Understood.
those rules.
Form.
And then if you have anything missing, make some formal discovery requests. But both Judge Marquis and I confirmed that we'll address that issue if it's been miscalculated or in some way his income has been misrepresented, then we'll deal with it.
Understood.
Yeah, for sure. So, Mr. Lytle.
So we'll get that in as soon as
Yeah,
possible.
I did. I ordered it for April 15th.
I had him. I actually went and looked at my trial notes or my hearing notes from today, and for some reason I had said before the pretrial conference, which is in June next month.
Right.
So anyway, that,
Okay, so you'll do your certificate of completion or you'll start, well, I don't even know if she can do the certificate of completion. She'll start her class within the next 30 days. I don't
Yeah,
know
sure.
when you'll get it complete. But if you can start it within the next 30, if it's being offered in the next 30, then start it. If it's not being offered within the next 30, start it at the next available class time. I just don't know when they offer it. And then with him in the FDF, we'll be back within a month, right? So
I believe June. I think
June
it's
25th, I believe.
25th. It's
Yeah,
a little beyond a
it's
month, but
a little longer than a month. If you can have it filed within the next 30, please,
No
oh
problem.
please, because I want to be able to look at it
Absolutely.
when we come back here.
I think, depending on when we get disclosures, I mean, I don't know if we're gonna be able to proceed to trial at this point until,
Right, you might need more time for discovery.
Shut
No,
up,
I
Fozzie.
understand that.
and I know it's drug on, and Mr. Lytle has made that point, and I understand it's drug on. I just wanna make sure that we're covering all the bases before we,
Right, so make your formal request then, so that you at least have that done, and then you can make your pitch to me at the time of trial if in fact you didn't get what you thought you were supposed to get.
Sure.
Right?
Understood.
I mean, look, at the end of the day, I can impute income, I can look at if he's covering expenses and if money's coming out of thin air, it doesn't make a lot of sense. And if he fails to disclose or fails to provide the information that is necessary for us to really do an evaluation of his income, then, you know, there's gonna be inferences drawn, and I'd rather not do that. I'd rather everybody provide us the information so we can actually utilize real numbers. So, so
No,
with
he
that,
didn't.
then,
No, it was like
you're gonna need to,
Fozzie wanted a chair from us that was like $9,000, heat and massage, and I don't know. He did not get the chair. No.
do your disclosures and get that FDF completed. And what I said was, get his 2 pages of his tax return if he's not, doesn't have a, because he said, I don't want a paycheck, right?
Right.
So, get his tax return, I don't know what his tax return says.
Right.
I don't know if it says he's in the hole every year, I don't know what it says.
Right.
But it may not tell me a whole lot, I don't know. So, we'll see.
No problem. Your Honor.
All right,
I
but
did
all
want-
those issues will be addressed at trial. So if we don't get the interim orders right, they're just, at this point, they're just a sort of like I said, like a Band-Aid, I don't want to call it that, but it's a Band-Aid at this point because
It's
we know
temporary.
that it's temporary. We may learn through evidence that it's just it wasn't right, and that's okay because we can fix it. So, and we will if we need to.
I
If
just
it's
wanna-
right, it'll stay the same. Yeah.
Right, absolutely. I just wanted to address real quickly, so on the exchanges that are happening at Metro,
Mhm.
I don't think any of us were aware of this, but from what I understand, that office in Metro is not even open at 7 AM in the morning, which makes it kind of a strange
We're
place.
talking about the main office?
Yeah.
It should be open 24
They open
hours.
at 8 o'clock for sort of regular business. I think there's people inside like answering the phones. So my understanding is that,
Well, there isn't any other that's open that early either.
I know, so I'm
Um,
wondering,
she's,
go ahead.
I'm sorry, Sean.
No, go ahead.
She's indicating they are open. But
I thought
maybe-
they were open 24 hours. That's the only one that's open 24 hours, as I understand. Is that right? Yeah, I mean, isn't that your understanding too, Tyrone?
Yes, you are.
Yeah, I think it's open. I don't know, I mean, they don't need to go inside,
Right.
right?
Right.
But it has a lot of police there and video cameras, and the
Right.
whole idea is everybody's supposed to mind their P's and Q's and act appropriately, but
Either way, I mean, if it's 7 AM, that's fine. One of the issues is that without fail, Ms. Sangalaz's father has been accompanying her for these exchanges and taking videos and just kind of causing some unnecessary drama. So what we'd like to do, and we thought maybe that was in response to the fact that there didn't seem to be anybody else around. So we were gonna offer to maybe just move that an hour later, but if we can address it another way, I'd be happy with that too, which is that we'd really prefer that no other family members show up and take videos and these sorts of things at exchanges. The whole point of having the exchanges at Metro was because it is a public place and all that stuff.
So before you say any more, the 400 South Martin Luther King Boulevard address is reporting on
Why you-
internet, pardon me?
Is that,
That's the main
Is that,
one.
okay,
Yeah.
yeah, sorry.
It says it's open from 8 to 3. Is that right?
That's been his experience, is that there's really nobody there.
Well, then there isn't one open all day. But
I mean,
they,
you can call.
Well, Your Honor, if they don't have to go inside, there's plenty of cameras around, and
Yeah.
obviously,
yeah, I mean, that's the point of it, right? Like, none of them are open,
Right.
okay?
But what I'm saying is, and again, we're giving her the benefit of the doubt that maybe the reason that she's showing up with family members with cameras rolling is because there's really nobody else there. It's not fulfilling its purpose as sort of a public exchange place at that hour. So to me, there are two solutions to that. One is we can keep the hour the same, but then we would ask that, you know, only mom come for the exchange and that we not be, you know, putting cameras in people's faces. Or
Doesn't
can we
it
just
doesn't
move it,
help.
or we just move it to 8 o'clock when there is actually like, you know, law enforcement presence, so that if something does get out of hand, that it's not gonna.
That's when they say they open is 8. Is that better? Is that okay?
well, Your Honor, here's the thing.
What, yeah, what? I'm trying to find a solution to the
So
problem.
if they're at the police station,
Mm-hmm.
regardless of whether they're inside or outside, they're at a cop shop.
Mm-hmm.
I mean,
Right, but she's bringing somebody there to
because
videotape.
she feels more secure when her dad's with her. Getting out, if he wants to shoot video, he can shoot video. If he's getting in the plaintiff's face, I will admonish him that he needs to,
How about, why does he have to shoot video?
because, well, if there's an incident, then you have to subpoena the video from Metro. and
That's
then
why
you
they're
have-
there.
I thought that's
I
why
mean,
we
that
were
was the
doing
point
it
of
Metro
it,
in the
so
first
that
place.
if they
Well,
had,
we would still like Dad there. If the court orders him not to videotape it, that's fine. But she is far more comfortable.
oh, look, if she has someone accompanying her, I don't have a problem with that. But the videotaping is just inciting
Understood. That's fine.
stress and negativity, right? So if it would make zero sense for either one of them to do anything in the front of the police department, okay? Not that it hasn't happened, but the police department,
I myself
It's
would pick
true.
a different place to do
It's
something
true.
stupid, but
no, people do it. But they have cameras and that's the whole point, and there are people there. But yeah, I mean, I was thinking if they were open at 8 o'clock and they could go in at 8 o'clock, but if they picked 7 for a reason, I don't know if the judge picked 7 before or whether
it's
it was.
7 works for my client.
Okay, works for her, that's fine. Then we're just gonna leave it at 7, but let's, no videotaping,
Okay.
no videotaping, but she can take someone to come here. But I would say he needs to stay in the car.
That's fine.
The parties need to do the exchange of the child, putting him in the seat, but dad needs to stay in the car
Understood.
so that there's no altercation, because they don't need to be in the middle of it. I mean, I understand him wanting to protect his daughter, and I understand.
Oh, dad needs to stay in the car. Her dad, not father. Okay. I thought the father had to stay in the car now, because enough is enough. It's her that's the problem, not this poor guy.
Understand that he's worried, but at the end of the day, they're at the police department, and the videotaping doesn't make a lot of sense.
Understood.
Yeah, because they have video. That's why they're there. Otherwise, I'd just send you to the local park. But that doesn't make any sense. All right. So, with that, I'm going to ask you to prepare orders regarding the different motions.
Shouldn't Mr. Leno, since I lost?
It's not how this works, my friend.
That's fine, I'll prepare that.
Yeah, I'm going to ask you to do it. And then we'll see you back here on June 25th, I believe it is.
Right.
And hopefully by then we can have some update as to financials and in terms of disclosures, not just the FDF. The FDF must be filed, okay?
Right.
But in terms of disclosures, so everybody's a little more satisfied with the information.
Will there
And,
be
and,
minutes?
and then I would highly recommend these two try to resolve this matter. What's that?
Obviously, we covered a lot of ground today.
Mm-hmm.
Will there be some minutes that are prepared? Or,
Yes, for sure.
okay.
Yeah.
I just didn't know if we were going to have full-on minutes or
Yeah, she'll
the short
do-
version.
No, she does great
Okay.
minutes, but,
Perfect.
what do you have
I'm
there?
sorry, we have this. That's the change of the this.
Okay, all right, so, what was I gonna say? So you're putting the order, we'll see you back on June 25th. Oh, and I was just gonna say, and then now that you're on the case, I mean, talk to Mr. Lytle if there's any potential for resolution. I don't know if there is or is not, but if the parties can reach an amicable resolution, their child will be far better off than if they have to go through a trial and start slinging mud and, you know,
Understood.
dragging each other through the process, because it's not pretty. And they
You
have
don't need your honor.
17, I know you do, I know, they have 17 more years to raise this child, and then some, you know, to go on to the things that happen when he becomes an adult, so.
I'll have
But
discussion.
best to start now. Pardon?
I'll have a discussion with Mr. Lytle.
Yeah, for
And maybe
sure.
we even, I'll discuss, I'll broach this subject, maybe even a settlement conference and see if that would be something that would.
Yeah, for sure.
I look
Okay.
forward to this call. All right,
Very good,
Your
thank you
Honor.
very much. Have a good day.
Luckily for us, they didn't settle, right?
Have a good day, folks.
Okay. We are on the record in the Ravella versus Sangalaza matter, case D572482. Counsel?
Good afternoon, Your Honor. Sean Lytle, 11640, on behalf of Nicholas Ravella.
Good afternoon, Your Honor. Carrie Pond, 12204, on behalf of Karen Sangalaza. Who is present?
She is?
Where's
I
Dad?
guess I should have thrown that in
What's that?
there. I guess I should have thrown that in
Yeah.
there.
Okay. All right, so this is the time set for the pretrial conference. Last we were here was, let's see, May 14th. I can't believe it's already been that long. Time just flies. All right, so how's everything going?
As far as I can tell, in terms of the week in, week out, things are fairly uneventful, which is a nice change in this case, so.
Right? Okay,
There's been a few things, but nothing that we need to address today.
Yeah.
okay. Are you two in communication?
Yeah.
Yeah.
Okay. All right, are you finished with your discovery?
Well, I came on kind of late, and Discovery was pretty much at an end, so,
Yeah,
What
I'm
is it?
actually,
I mean, do we want to extend Discovery? Is that something you're?
the
open
problem
to?
right now is I don't think we have, I was just checking it again this morning, I don't think we really have a trial date, and I think there's.
No,
some
you don't, that's why
confusion.
we're here.
Right, yeah, so I think,
That's why- what
I think
I'm
we're a little bit
asking is-
confused about when the discovery deadline
Well, it's
is
supposed
at
to be
this
now,
point.
it's supposed to be
Right.
today.
Right,
That's why I was asking is everyone done, or do you need more time?
If Mr. Lytle would be so kind as to allow me maybe 60 days, because as you know, I came into this
I'm fine.
way late, I appreciate, just at least, I may need nothing, but just in case, I'd like to have that opportunity.
Okay,
I'm fine with that, and we're actually gonna be putting together a settlement proposal in the next couple of weeks, so, again, we just really kinda wanted to get this thing back on track, and for the most part, it seems like that's occurred, so.
Well,
At this point, hopefully we can get all this resolved without having
it
to
would be nice.
exchange hundreds
It
of
would be
pages.
healthy for them, I
It
think,
would.
if they can resolve it, but I don't know. If they can't, then we'll go to trial. What's that?
I said, I'm sorry, I had to take the credit for getting it back on track.
There you go. Okay, whatever it takes. All right, so with that then, what I'll do is I will say that
It's the
you have
same
another
one
60
as
days of
last
discovery.
time,
The
though.
discovery will remain open for 60 more days. Let me look real quickly here.
I put it end of August.
Well, that's not 60 days from now, is it? Yeah, I
Well,
guess
it's
it
the end
is.
of June, so.
Yeah, I was like, wait a minute, what is today? 25th. Yeah, it is the end of August. Wow. Time is just flying.
And see, my excuse is always, I became a lawyer, so I didn't have to do math, and I was able to do that one.
That was good. Good for you. Okay, so yeah, and this case has been open since June of 18, so we need to get it moving. So, the question becomes, the end of August, do I set a trial date, or do I see you at the end of August to determine trial dates?
I would prefer to go ahead and set a trial date.
That's fine,
Okay.
I'm fine with that.
So, let's see here. End of August, and then 30 days later. That time frame has a bunch of, like a week-long trial.
Well, the end,
the 3-day trial. Pardon?
Mid to end of September, I have 2 trials already. So if we could go maybe early October, if that's,
I'm fine with setting it out, you know, a little bit further than we would expect normally. So if you want to do, and frankly, I should probably check. I mean, I've got holidays,
Tell me when they are.
so I mean the big ones are going to be September 30th and October 1st. and
Okay,
then-
high holidays. You won't
Yeah,
have.
and then October 9th. So really, if we can get past October 9th, then things are clear for me.
Are you able though to prepare if I were to set something, let's say October 10th?
and I'm
Or
willing to
go
work
farther,
I'm willing to work with
council?
his religious schedules.
I'm good. I'm good with the 10th.
That the 10th or the 17th of October, either one. Why do we have the 10th blocked
The
off?
17th is in the middle
Let's
of.
do the 17th. 17th is gonna what?
17th is right in the middle of Sukkot, which is another holiday. My kids
know
are out
it.
of school. We might be out of town. So I would prefer to do before that. If we can do the 10th, or we can go even the last week of October. Everything's done.
No, can't do that week. Can't do that week. I can do the 21st. Are you able to do the 21st?
No. The last of the holidays, they all come bunched together at that time of year. The last of the holidays is October 21st and 22nd,
Can you have someone cover for you?
and then I'm good. I can't. No. I'm a sole practitioner
Is the 24th or not?
You said the 10th worked?
The 10th works.
What'd you say about the 24th? He can't. He said he can't do that week, unless the 24th. Does the 24th work for you?
And you say the last week?
24th is fun.
All right. You want to do the? How about you?
Are you
The
good with-
10th or the 24th? October 10th or October 24th? I want to hear from her too.
They're both Thursdays.
Okay.
24th is fine.
Does 24th work? Okay. All right. 24th. So we will do. Do you want the whole day?
Yes, sir.
Okay. We'll have the whole day.
And again, we're going to work really diligently on trying
To
to
try and
actually
settle
resolve.
it.
But if
That'd be
we
great.
can't resolve it, it's going to take the day.
Okay. All right. October 24th it is.
Will you issue a trial order or?
Well,
Or do you
if
want
I
us-
could get
you want
my,
me to
if I
prepare?
could get my scheduling orders to work, I would love that. Okay. Here. So you know that Discovery closed, you don't have a problem with it closing 60 days from now, or do you want it out even farther? Because it doesn't really matter, I mean, if you need the time.
Yeah, I mean,
Because we have October
We
24th,
could do 90,
so, yeah.
because that would put it
Gotta put
a
it
month
right,
before.
right a month before, correct. So
that's fine.
let's do September 24th then,
perfect.
is the Discovery close. And then pretrial memos we do 14 days before trial.
On the 10th.
And then exhibits and witness lists exchanged 1 week before trial. And then you can submit those to the court 3 days before trial. So I'm gonna have Mr. Lytle prepare that. How's that?
Sure, that's fine.
Okay. Got all those dates?
I'm sorry?
So you have all those dates? He's gonna prepare
I don't
it.
have them all, but I'm assuming they're going to be in the minutes.
Yeah, they are. Well, it's just 30 days before trial, or September 24th, let's just say, for close of discovery.
Perfect.
And then 14, 7, and 3.
Right.
Okay?
Very good.
All right.
Thank you, Aaron.
Thank you so much.
Thank you.
Okay, this is case number D1857248-2C, Nicholas Rebella versus Karen Sangalaza. I'm sorry if I massacred that.
New
welcome,
judge.
Counsel, please state your name for the record.
Good afternoon, Your Honor. A Lytle, 11640 on behalf of Nicholas Rebella.
Okay,
Good
welcome.
afternoon, Your Honor. Carrie Fonens, bar number 12204, on behalf of Karen Stengalaza.
Okay, so before you guys start arguing, I can tell you I agree with defense counsel's position that it's not proper before me, because it's not. Had you done a formal discovery request for the card, then I could enforce that, but you have to bring that before the judge, and those are all issues for the judge. And it sounds like you guys, I mean,
I don't know how it ended up in front of you, to be totally honest.
Oh.
I mean,
okay.
we didn't request that. I mean, we
Motion to compel and for fees and costs. You know, and I have other things too, like a motion to
So-
continue a trial that got set before me that needs to go before the judge. So these clerk's notices, okay,
I was hoping that, when I pointed that out, I was hoping that that would trigger them to reset
to
it, but.
kick it.
I
And I,
frankly didn't think we were gonna have a hearing on this at all. I'm asking for an insurance card, and I assumed that just
Yeah.
filing the motion was gonna get that. to
yeah, and
me.
it doesn't say it's supposed to be before me, so it's the clerks that kicked it over
Yeah.
here. So yeah, unfortunately, you guys try and work it out and get
Yeah.
that done, because I agree that he should have the insurance cards, but I have no no authority. So
Right.
I'm not even gonna, I guess I'm just gonna let the minutes suffice that you guys were present,
Perfect.
that it got set before me by mistake, and somehow you guys have to try and get it set before the judge, or please work it out. That would work out the
Absolutely.
best.
Your Honor, I can tell you, as Mr. Lytle, that I'm doing my best to get some compliance, and
Okay.
I'm having.
Just tell your client, she said that
to give
Insurance
you a
cards
card.
are
If
important.
anybody
Insurance
can
cards are
come up with a
important,
card.
so-
it's not a misrepresentation.
That is
Thank you for
not.
thank you for coming to court, and happy 4th of July.
You too, thank you.
Thank you.
Take care.
All right, we're on the record in the case of Nicholas Ravello versus, and is it
New judge.
pronounced Karen or Karen?
Karen.
Karen. Sangalaza. And this is a child custody complaint set for an evidentiary hearing / trial today. Appearances for the record.
Good morning, Your Honor. Sean Lytle, 11640, on behalf of plaintiff Nicholas Ravello, who's present.
And you're Ms. Sangalaza?
Yes.
And you're representing yourself, is that correct? Okay. Very good then. You can be seated, and so can Mr. Lightfoot. I just want to, and you don't have to jump up every time you address me. If you wish to do so, that's fine. But I read the pretrial memorandums, and I read the previous minutes and orders in the case. And so this is an evidentiary hearing to determine the custody arrangement. The custody arrangements that were previously ordered by Judge Gentili and Judge Marquis were temporary orders, not permanent orders. They were intended to be the orders in place only until the trial today, so this would be the trial on what the permanent orders would be. So at this point, Mr. Lytle, are you seeking joint, primary, or sole physical custody?
We're seeking sole physical custody.
All right. And Ms. Sangalaza, you had discussed both primary physical custody and sole legal custody, or excuse me, physical custody. Which do you wish to, are you planning on pursuing today?
Sole custody.
So for the record for both of you, the Nevada legislature has created a presumption that joint physical custody and joint legal custody is in the best interest of the child. In order to overcome, each of you has the burden, respectively, to overcome that presumption. Okay? Which means that you have to present evidence that convinces me that it is not in the best interest of the child to award joint physical custody, and that one of the two of you should either get sole legal custody or primary physical custody, with the other parent having certain visitation. I will also note that asking for sole physical and sole legal custody is an extremely high burden, because it is an equation by the Nevada Supreme Court almost with termination of parental rights. So rarely does a court award that, and that would require proof by very significant evidence. So I'm just letting you know that that's the standard that you would both have to comply with. So with that in mind, are there any preliminary matters you'd like to raise with regard, Mr. Lytle? I'm not going to have opening statements because I want to save most of the time for testimony, so. And I did read your pre-trial memorandums.
Okay. We're not gonna do opening statements, that's fine. I did want to figure out what we're going to do in terms of, well, I sort of have two housekeeping matters or questions. The first involves the fact that, excuse me, there are only, Ms. Sangalaz has only identified 3 witnesses, one of whom is herself. Obviously, she's entitled to full participation in the
Can I
proceedings.
object to that? I have,
One moment. I think she identified actually 3 in addition to herself.
Correct. I stand corrected on that. The two of those 3 additional witnesses are her parents, who we had sought to depose in this case the day before their depositions were to go forward. We received notice that they would not be participating in those depositions. This was right on the eve of what was to be calendar call for the previously scheduled trial before the case left Judge Gentile's department. I'm not sure exactly what the nature of their testimony would be, but I would like to impose some restrictions on their ability to offer direct testimony in light of their refusal to participate in duly noticed depositions. So that's question 1. And then question 2, or issue 2, I guess, is because Ms. Sangalaz is representing herself today. I'm not entirely sure. I don't want us to get bogged down in a number of objections in terms of her questioning of our witnesses. And so I'm wondering if the court would be willing to entertain some sort of standing objections with respect to certain lines of questioning, so that we can keep things moving today. I'm just not sure what the court's preference is on that particular issue.
So,
can I respond?
hold on for just a minute. So the first issue is that he's asking that your parents not be allowed to testify because they failed to appear from the deposition after being noticed of the deposition. So that's the first issue that you would need to address. That would not prohibit him from calling them as what is known as an adverse witness, or for you calling them to rebut testimony that was presented in his case in chief. But that's what his request is. So now you can respond to that, and then we'll deal with the second issue.
Okay, so the first issue, when it comes to the deposition, at our house, we received the depositions about less than 2 weeks before we were supposed to appear. My parents already had plans to be out of town. They were not, they were out of town, and they sent, they emailed, they emailed and they emailed a letter saying that they were unable to. I personally, that was my first week of classes, so I had to deal with financial aid. I already had appointments with financial aid, and I had appointments with my professors. So, I mean, you can't send out, you can't request
How soon after you received the notice did you send the information that you would not be available on those days?
The day before we were supposed to go, we emailed the letters. But because there's no timeline that says we have to, respond to that type of notice in a certain amount of time. We were given that notice less than 2 weeks before we were supposed to appear.
Okay. So the first thing is the notice was adequate. That's a reasonable period of time. If you had conflicts, the wiser thing
Fly,
to do
Eagles,
is
fly.
not to wait till the day before to notify the parties, because then they don't have a chance to reschedule it for a time period when you might be there. However, I am not going to employ a sanction that prohibits your parents from testifying in your case in chief, that is when it's your turn to present your evidence. But it may, you're not attending the deposition and they're not attending the deposition. Mr. Lytle is free to argue how that affects credibility. Okay? The second issue, Mr. Lytle, is that to enter a standard objection to certain topics without you telling me what those topics are, no, I cannot do that. So if you want to object, and I sustain an objection for particular reasons, and then, and this is true of either side, then you don't have to keep objecting if it's the same issue. I'll simply note, no, I already said you can't ask that question to either one of you, or that the witness can't give that answer to either one of you, depending on what it is. Because you are
Critter,
representing
hi.
yourself, there is a certain amount of job that I have as a gatekeeper of the evidence to ensure that the trial is evenly placed. That simply means that if something is obviously objectionable under the rules of evidence, and you don't object, same thing is true, Mr. Lytle doesn't object, I do have the authority to say, no, that's hearsay, for example, and I don't see any exceptions, this is the technical way to phrase it, to the hearsay rule. So I'm not going to allow that question to be asked, and any part of the answer that started to come out before I started speaking would be stricken. And that applies to both of you, okay? And there are rules of evidence, though, and I cannot simply relax them because one party has an attorney and one party does not. Okay? All right. Anything else that's preliminary, Mr. Lively?
No, Your Honor.
Any other preliminary matters that you'd like to raise?
Yeah, I'd like to open the courtroom for people to be able to observe it and see what's going on.
Well, if you have people who are going to be witnesses, they're not allowed to be in the courtroom while they're testifying.
Non-witness.
Is there someone that's a non-witness that you want in the courtroom? I mean, they would not then be able to discuss the matter with you or anyone else. In other words, that person goes out and starts talking to your other witnesses, that would cause those witnesses not to be allowed to testify. So, and that person would not be allowed to testify themselves if you suddenly decided that something came up that you would want
Fozzie, Nan deleted your last comment.
that testimony. Is there?
Right, that's fine. Yeah, no, that's fine.
I just wanted to make sure, you still want somebody in the courtroom that's, okay, and who would that someone be?
Mr. Steve Stanson.
Okay, and, he's just your friend, or,
Yeah.
okay? And,
Your Honor, we're going to object to that. Mr. Sanson operates a website, Veterans in Politics International. He's already been sort of weighing in on this case publicly and making disparaging statements about parties, counsel, and judges involved in this particular matter. And there is absolutely no legitimate basis for him to be in the courtroom today. We're talking about a very young child, not even 2 years old yet. And I would ask that, with the exception of the witnesses as they are called, that the courtroom be closed for today's proceedings to outside observers.
on what basis do I have to close it to the public?
Again, because we're dealing with a very young child here and we're dealing with some very sensitive issues, and because with this particular witness there is a history of basically in real time, commenting publicly about what's going on in the courtroom.
One cannot report from the courtroom, is that your concern?
That is my concern, yes.
If he can certainly watch, but he cannot report from the courtroom, which
Absolutely.
means that his electronic devices need to be lodged with the marshal.
Absolutely.
Okay? That would be appropriate, so you can ask Mr. Sanson to come in under those conditions. Okay? So you can allow him to come in, and I'll let him know what those conditions are, and then he needs to get his communication devices to.
Thank you, Your Honor.
Mhm.
He's no longer outside.
Oh, okay. Very good. Then in that case, we'll go ahead and we'll start with the witnesses, and if you'd call your first witness, Mr.
Thank you, Your Honor. Call Nicholas Rebello.
Okay.
You can remain standing with your right hand to be sworn.
You do solemnly swear testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Good morning, Mr. Rebello. Could you please state and spell your name for the record?
Nicholas Charles Ravello, Nicholas, Charles, Revello.
Thank you. And you are the plaintiff in this action, correct?
Yes.
All right. And we're here today to discuss custody for your son, correct?
Yes.
And what is your son's name?
Julian Samuel Ravello.
Okay. And how old is Julian?
It's about 19 months.
Turned 19 months yesterday, correct?
Yeah.
Objection, leading question.
It's not asking for significant information that isn't already part of the record, so all of them will be objection.
All right. And Julian's mother is also a party to this case, correct?
Correct.
And what is her name?
Karen Sangalaza.
And she's the defendant in this action?
Yes.
Okay. And you see her, she's present in the courtroom today?
Yes.
Okay. I'd like you to tell the court how and when you met Ms. Sangalaza.
We met in the summer of 2017, I think in June, here in Las Vegas.
And did you pursue a relationship with Ms. Sangalaza?
Yes.
What was the nature of that relationship? Was it friendship or something more significant?
It had to have been a lot of mushrooms. That's the only thing I can think, because she transformed into like a dragon or something, so he didn't know who it was because of the mushrooms.
Yeah, we started dating as soon as we met. We were inseparable, spent every night together for many months.
And how would you describe the relationship between you and Ms. Sangalaza in the summer of 2017?
A lot of fun. Yeah, very positive.
Now, at some point, Ms. Sangalaza became pregnant, correct?
Yes.
With your son Julian?
Yes.
Okay. When did you find out approximately that she was with child?
We found out in late August after we had moved to Wisconsin together.
Okay.
Of what year, sir?
2017.
So later in that same summer?
Yeah, about 2 months after we met.
Okay. And what was your reaction to the news that she was pregnant?
I was shocked.
Shocked in a good way or in a bad way?
In a, this is very unplanned sort of way.
Okay. All right. Did you make any plans with Ms. Sangalaza as to, how you were going to proceed with the relationship, if at all?
Well, we were living together at the time, and we were dating with no signs of stopping. And once she was pregnant, I thought any decisions regarding the child should be up to her
Okay.
at that point.
Meaning what?
Meaning if we wanted to pursue raising the child or other avenues like, I don't know, adoption, I wanted to let her make all those choices.
Okay. And you said you were living in Wisconsin at the time?
We were at my home in Ripon, Wisconsin.
When did you move to Wisconsin?
It was probably early August of 2017.
And it was after you had moved to Wisconsin that you learned of the pregnancy?
Yes.
Okay. When did you meet any other members of Ms. Sangalaza's family?
I don't recall if I met them that summer. I know I did spend Thanksgiving of 2017 at their home in Las Vegas.
Okay. Were you still living in Wisconsin at the time, and you traveled back for that, or?
Yes.
So her family was living still in Las Vegas, you were living in Wisconsin with Ms. Sangalaza, and you traveled back for the Thanksgiving holiday in 2017, is that what you said?
Yes.
Okay. Was there discussion of her pregnancy at that Thanksgiving gathering?
Everyone was aware, as far as I know.
And what was the reaction of her family to the pregnancy?
They seemed supportive.
And when we're talking about her family, how many people are we talking about?
Her family at that time was living in North Las Vegas. It was her mother and father and her two siblings, Isabel and Barrett.
Okay. So it's a sister and a brother?
Yeah.
Was there discussion with her siblings about the pregnancy at the Thanksgiving gathering?
Objection, leading question.
The question is,
It was already
calls
asked.
for a yes or no answer. So I don't think that it's leading, but the issue, all right, just a moment, we'll take a break. Mr. Sansone, I assume, from your t-shirt?
Justice Becker, how are you?
I'm fine. I have indicated that you may be in the courtroom, but you may not do live reporting from the courtroom. So if you have any cell phone or a tablet, if you would.
No, ma'am.
Okay,
I know the rules, ma'am. Thank you.
that's fine. I just wanted to let you know.
Thank you, ma'am.
All right. Please proceed. I'm sorry. The objection was on leading, so I overruled it. But the issue is just whether or not you had discussions, not what those discussions were.
Yeah, her entire family was well aware that she was pregnant.
Okay, all right. And I think you said that her parents were supportive. Were her siblings supportive as well, or?
It seemed that way.
Objection, leading question.
Sustained.
Okay. What was the reaction of her siblings to the pregnancy?
They seemed fine with it.
Okay. All right. Where and when were you, or where were you residing when Julian was born?
A couple months before he was born, I moved our family out to Las Vegas because Karen was back in school and living with her parents. So I came out and rented an apartment. We were all living together. So we were living here in Las Vegas when he was born.
Okay. And were you present at Julian's birth?
I was. I drove his mother to the hospital.
Who else was the, you said the hospital, which hospital?
Summerlin Hospital.
And who else was present at Summerlin Hospital when Julian was born?
His mother's parents and her friend Bree and myself.
All right. So, you said earlier that the relationship prior to, or in the early days was, I think you said fun, right?
Yeah.
Okay. After Julian's birth in April of 2018, how would you characterize the relationship between you and Ms. Sangalaza?
Abusive.
Can you elaborate on that?
For the 3 days we spent in the hospital after he was born, she didn't sleep, and neither did I. I was staying awake to allow her to sleep, and she verbally abused me for 3 days straight, including threatening to leave me off the birth certificate.
Did she leave you off the birth certificate?
No.
So you are identified as Julian's father on the birth certificate?
I'm definitely his father.
So at the time, you and Ms. Sangalaza were living together in an apartment you rented here, correct?
Correct.
Okay. Is that the apartment that you took Julian home to when
Objection.
you left the
Leading
hospital?
question.
Sustained.
Where did Julian first live when he was born?
I wanted him to live at our apartment with myself and his mother, but her family insisted that they go to live in North Las Vegas. And they put him in their car and left without our consent. They essentially kidnapped him right from the hospital.
Who all went in the car with them?
Her mother, her father, and her, and the baby.
Her meaning?
Julian's mother, Karen.
Okay. Okay. Did you receive any communications from Karen and or her parents after they left the hospital?
Yeah, we were communicating.
You're communicating by text message?
Yep.
Objection. So leading question.
It's foundational, I'll allow.
Go ahead, may I approach the witness?
You may.
Mr. Rebella, I'm handing you a stack of proposed exhibits for today's proceedings, and I'd like you to look at Exhibit 1.
Your Honor, can I object? I've never even seen, I was not sent a copy of these exhibits. I didn't even know that they had any exhibits. On their pre-trial memorandum, they listed that they were just going to use the exhibits that were already entered and the talking parents' messages. The exhibits that were already entered were my own exhibits, if you look back in there.
These exhibits were
One
previously...
moment. So the pretrial memorandum indicated that it would use the exhibits that had been previously attached, they were never admitted,
Correct.
previously attached to the parties' pleadings, either ones. So that's what he indicated. Did you send a copy of the exhibits to her, Mr. Lytle?
Of this particular arrangement of the exhibits?
Were the exhibits produced to her at any time prior to this proceeding?
Well, again, so for example, Exhibit 1 that I'm asking him to look at right now was attached to a counter motion that was filed very early on in this case, and it was discussed at length in court.
Okay. So the first thing is to have him identify exhibit number 1, and if you look at it, ma'am, if it's a document that was previously attached to a motion, then you would have had notice of it from the pretrial memorandum.
All right, guys, we hit the end of our time today. Whew, that was good. That first part with her screaming at the judge was great. I might have to make some shorts of that. I know, Katie. I know. I can't wait to see what happens next. I can't wait until she questions this father. Oh my goodness. So yesterday, when we ended, we were dying to know if she actually turned over the child. And of course she didn't. And then the police got involved, and then a new order got involved. Now today we're wondering what's going to happen when she questions this father. It's going to be bad. I know it. I know it. I know it. So, but we'll find out in what, 22 more hours. Don't do what Bren did and look ahead. It's not fair. Mia knows, Throw the Goat knows, Bren knows. Everybody else knows what's about to happen except for us. All right, guys, I know. Drunken, I know. There's nothing I can do. I can't play the whole thing in one day. I'm not going to. I got this. We'll just figure it out like we did today. You screenshot it. Bye, guys. I will see you again real soon.